Today's session, Law, Order, and Algorithms, a computational approach to criminal justice reform, will be led by Sharad Goel. Sharad is a professor of public policy at the Harvard Kennedy School, and he looks at public policy through the lens of computer science, bringing a new computational perspective to a diverse range of contemporary social and political issues, including criminal justice reform, democratic governance, and the equitable design of algorithms. Prior to joining Harvard, he was an assistant professor at Stanford University, and he holds a BS in mathematics from the University of Chicago, as well as a master's degree in computer science and a PhD in applied mathematics from Cornell University. Thank you for joining us today, Sharad. I'll pass it over to you.
Thanks for that introduction, and thanks everyone for joining today. Just to check, can folks see this?
Yes.
Good, great. So today I'm going to give you a little bit of an overview of work that my collaborators and I have been working on for the last, I'd say 10 years or so, on problems at the intersection of computer science, data science, and the criminal legal system. And broadly, I think of these problems is falling into a few different buckets of data collection, data analysis, and then algorithmic tools and interventions. I'm going to give you a taste of each of these different buckets, starting with a brief description of this open policing project that we started about 10 years ago, ways to assess discrimination in policing, and then finally a couple interventions that we've recently rolled out to improve outcomes in the criminal justice system. And I'll try to keep this pretty informal, so feel free to ask questions throughout, and we can address them as they come up. So the first part, I want to talk about work that we've done to drive reform in the criminal justice system using data analysis. And in the second part of the talk, I'll discuss some of the algorithmic interventions that we've recently deployed. So about 10 years ago or so, in fact, this was one of the first projects that I started when I became a new faculty member, was what's now called the Open Policing Project. And at the time, I was really interested in understanding, in measuring the extent to which there's discrimination in policing, in the patterns of that type of discrimination. But there was very, very little publicly available data or easily accessible data on that question, making this quite difficult to make headway on. And so we went out and we started filing public records requests at all 50 states and in about 100 different cities. And at the time, I guess I was probably pretty naive. I was like, okay, this is a big effort, but maybe it's going to take like a year or two to get all of these records. 10 years later, we're still going. To date, we've collected about 250 million individual records of traffic stops all across the country. We've analyzed about 100 million of those records. We've posted everything online, including all of our code, all of our analysis. So this has really kind of taken on a life of its own, and is now a resource that I hope is valuable to many folks, including some of you listening today. And so I want to give you a little bit of an overview of what type of analysis one's able to do with these data. So the first question, again, the motivating question here is to what extent is there discrimination in traffic stops? And there's a lot of kind of trickiness here, and there's a philosophical trickiness of what does it mean to discriminate, and this is something we're going to get into a little bit later in the talk. But I think we all kind of have this sense that at least one type of discrimination, what's often called disparate treatment in the legal community, is something like the action that somebody takes is conditioned on my race. And so, from this police officer perspective, the likelihood that they're going to stop me depends in part on their perception of my race. Now, that's a very hard thing to tease out from the data and to actually see, is that happening? But there's this idea that's called the veil of darkness test. This is something that a couple of researchers, Groger and Ridgway, developed, and is based on this very, very clever idea. It's a simple insight. So the idea is that it's harder to infer the race of a driver in night when there's a veil of darkness, a so-called veil of darkness. And so because of this, if it turns out in the data that Black drivers comprise a smaller fraction of the people who are stopped at night than who are stopped during the day, it could mean that race affects your stop decisions, because it's harder to see someone's race if in that condition, if you see fewer of the people who are stopped are Black, that suggests that in fact race was driving that stop decision. But this is not the entire story. So hopefully that intuition makes sense. But also with a little bit of thought, you might realize, well, driving patterns might also change by time of day. And again, hypothetically, Black drivers may be disproportionately out on the road during the day, for example, due to employment patterns. And then if that were true, you would just naturally see, even in the absence of discrimination, you would just naturally expect to see fewer of the drivers who are stopped at night being Black. Right. And so if there are these other variations other things that are happening with time of day, you might kind of get this funny effect. And so the insight of Gregory and Ridgway is to account for this possibility, use the fact that the sun sets at different times throughout the year. So now if you look at everyone who was stopped at 7 o'clock, 7 p.m. wall clock time. So here, ideally, this is adjusting for differences in work patterns and such. So it's 7 o'clock. But in the winter, it's dark at 7 o'clock. In the summer, it's light at 7 o'clock. So accounting for that time of day, we still see this variation in when you can see somebody's race. So sometimes in the winter months, you can't really tell someone's race at 7 o'clock. In the summer months, you often can. And this is what allows us to tease out the extent to which race is actually driving stop decisions. And similarly, you can still make this argument, well, okay, winter is different from the spring, other things might be changing. And so Grogan and Ridgway even go one step beyond this and say, well, let's just look at these abrupt changes, for example, daylight savings time. So all of a sudden, nothing really has changed except for we have decided to change our clocks. And now all of a sudden, do we see this difference in who is stopped when it's dark outside and when it's light outside? So this is a very, very clever idea, but up until this, so they proposed this in 2006, and at the time, there still wasn't a lot of data available to answer this question. So in some sense, this was a theoretical kind of exercise of this type of test. But when we collected these 100 million plus stops, we're actually able to put this test, we're actually able to use this test to directly examine the extent to which race might be driving these decisions. The first time when I heard this test, I was like, oh, this is super clever. But it's actually true that you can't easily tell people's race at night, but you could tell it during the day. So I actually went outside and stood there and tried to watch these cars go by. And in fact, it is true that at 7 o'clock in the summer, you can tell people's race often. In the winter, you often can't. And so this does seem to be an actual veil of darkness that is obscuring race. Okay, so now with that background, let's look at the results. And so this is just one kind of illustrative example to get us started. And so these are all traffic stops in Texas over a span of a few years. And I've restricted here to stops that are occurring in this 15-minute window between 7:15 and 7:30. And so what we see here is this is showing the percent of people who are Black. We're limiting to white and Black drivers, of stop drivers, the percent of stop drivers who are Black when it's light outside and when it's dark outside. And here, this is kind of this in-between after the sun sets, as you probably know, after the sun sets, there's about a 30-minute window where it's still kind of reasonably light outside. And so we exclude this gap, but we're looking at places where it's light and places where it's dark. And we see this really stark gap. So all of a sudden, as soon as it gets dark, we see this quite dramatic drop in the proportion of people who are stopped who are Black. Now, this holds not only this one window, this is just kind of this illustration. If we look at these other windows, if we look at 7 to 7:15 or 7:30 to 7:45, we see exactly the same phenomenon, that any of these windows, when we adjust for the wall clock time, we see these stark drops immediately after it gets dark, which is strongly suggestive of again, this idea of disparate treatment, that stop decisions are in part driven by the color of one's skin. So here I'm showing this for Texas. We repeated this analysis all across the country using the data that we have available. And again, this is a finding that largely holds across the country. Okay, so this is kind of one of the first things that that we did, or we're just going to want an illustrated example of what we could do when we have this type of data that we collected. Now, I want to pivot just slightly and now talk about stop and frisk in New York. And this is actually the project that really got me started in this type of work about 10 years ago. And so stop and frisk, as many of you probably know, is this controversial policing tactic. It's illegal in theory, and it's often used in many major cities across the country, where officers stop, question, and potentially frisk individuals on the street, pedestrians often, when they suspect criminal activity. And in New York, this was a quite common policy up until about 2013. There were about 500,000 stops conducted each year in New York. New York is a big city, but 500,000 stops is a lot of stops. The practice has substantially been curtailed in the intervening years, in part because of these court cases that I'm going to talk about now. So with stop and frisk, there are a couple issues that really give people pause about this policy. And one is this idea of discrimination that we've just been talking about in terms of traffic stops, that the people who are stopped are predominantly Black and Hispanic, and there's this real concern that this policy is not only having a disparate impact on communities of color, but is in fact kind of laced with racial animus. And so that's kind of one bucket of concerns with stop and frisk. Another bucket of concerns is that often people are stopped, kind of regardless of race, often people are stopped without any real purpose. And so one statistic to kind of highlight this belief is that in 90% of cases, 90% of the times that people are stopped, they're released without any further action. No arrest, no citation, nothing happens. But at the same time, these stops can be quite invasive. And so even if nothing is happening downstream, you might think, well, what was the point of that stop in the first place? I mean, is this really just a form of harassment? And so this is codified in the Fourth Amendment of the Constitution, this right to be protected against what are called unreasonable searches and seizures. And so, clearly this is a thought that was top of mind for the founders, and it's something I think intuitively resonates with many of us, that we have this right, that we shouldn't just be walking down the street and then police can stop us without any kind of just cause, without what's called a reasonable suspicion. So this is the context. These are these two kind of big buckets of concerns that have been raised with this practice of stop and frisk. So there was this court case, and I was living in New York at the time. This was 2013. There was this court case that was going on, Floyd versus City of New York. And I remember reading this line in the opinion by Judge Shedlin, and she says, the magnitude of Fourth Amendment violations that have taken place in this case will almost certainly never be known. And that was a line that really struck me when I first came across it. And I was thinking, over the years, there have been millions of stops, literally millions of stops that have taken place in New York. And it's like, it didn't feel right that we're not going to know, we're not going to know which of those cases, or how many of those cases result in people's constitutional rights being violated. And so this got me started thinking about, can we take a statistical approach to this question? Can we operationalize this question statistically of detecting reasonable suspicion? So at the time, and still, the sort of way that courts decide whether or not someone's Fourth Amendment rights were violated, whether reasonable suspicion was present when a stop was conducted, is to talk to the individuals involved, talk to the police officer, talk to the people who were stopped, talk to potential witnesses, and then determine based on those facts whether or not the stop rose above this bar of reasonable suspicion. And so this is obviously not something that can easily scale to millions and millions of stops. And so what my collaborators and I were interested in is trying to identify a statistical approach that relies on the data to help us estimate this quantity. And so here we use this very simple idea of saying, let's look at, based on all of the available information that an officer conceivably has right before deciding whether or not to make the stop, does the available evidence suggest that the likelihood of success, whatever that means, whatever the likelihood of stop success is reasonably high? And I'm going to elaborate on this, but this is the kind of the basic idea that based on all the information, is it the case that the likelihood of making a successful stop is reasonably high? And if so, we say, well, that stop was quote unquote reasonable or was predicated on reasonable suspicion. And if not, then we'll say that it is in violation of this Fourth Amendment protection. Okay, so what did we do? We looked at all the data in New York, in some sense by virtue of a series of longstanding court cases that have investigated these practices in New York. There's now quite a bit of transparency around these stops, and in particular, we analyzed about 3 million records of 3 million stops that were recorded by the NYPD, New York Police Department, from 2008 to 2012. And we restricted, in particular, to these, about 1 million instances in where an individual was stopped for what the officer suspected was quote unquote criminal possession of a weapon. And the reason we did that is that when you stop someone for suspicion of criminal possession of a weapon, arguably that stop is successful if you ultimately found a weapon. If you didn't find a weapon, well, that suggests that maybe that stop was in fact not predicated on reasonable suspicion. Okay, so we have lots and lots of information about each stop: the date, the time, the location, the demographics of the people involved, the suspected crime, as I just said, various outcomes, whether or not someone is frisked, whether or not a weapon was found. And we also have quite detailed stop circumstances. And so, these something like, was the individual carrying a suspicious object? Were they acting evasively? All of these different types of features that an officer can mark down when they're making these stops. And so we take all this information, we throw it into this gigantic statistical model based on all this available information, and we predict whether or not a weapon is likely to be found in this stop. So we take all the information available immediately before that stop decision, has to be made in theory. And we say, based on all that information, was it reasonable for an officer to think that they would recover a weapon? Remember, these are stops for criminal possession of a weapon or suspected criminal possession of a weapon. And so that's why we're looking at the likelihood that someone will reasonably discover a weapon in that interaction. Okay, so what do we find? We find about 40% of the CPW stops, criminal possession of a weapon stops, have less than a 1% chance of turning up a weapon. And so this seems like a large number. Now, again, it's hard to know, and I'm going to go into this in a minute. Is 1% really the threshold for reasonable suspicion? If you have a 1% chance of recovering a weapon, do we say that rises to the level of reasonable suspicion? I think reasonable people can disagree on this, but it seems relatively low to me, that 1%. And here we're saying in 40% of those instances, and 40%, again, over the years, there have been millions of these stops. In 40% of these instances, we have less than a 1% chance of recovering a weapon. So that's a lot of potential Fourth Amendment violations. Okay, so this, not only is there, a lot of people are being stopped at this low kind of evidentiary threshold, but in fact, this has this disparate impact across racial groups. So about 50% of stops of Black individuals are less, have less than this 1% ex ante chance of finding a weapon. About 30% of stops of Hispanic individuals and 20% of stops of white individuals are below this threshold. So really, we see this quite large gap, this racial gap in who is impacted by these low stop thresholds. Now, one thing I should clarify here is that weapon, and even you might think this is naturally think this is a gun or something. Actually, a weapon in most of these cases is a knife, and so not often these are this still potentially could be dangerous, but this is something to keep in mind, that what are we actually discovering? So discovering guns from these interactions is very, very, very infrequent. But any sort of weapon that's classified by the police, for example, a knife, that's what we're talking about here when we talk about this 1% chance. Okay. So going back to this question of, does 1% constitute a reasonable suspicion? Is that a reasonable threshold for characterizing this constitutional standard? Now, what have the court said about this? Well, they're a little bit they're a little bit circumspect in what constitutes reasonable suspicion. And so this is kind of one statement. So reasonable suspicion involves something more than an incoherent, an unparticularized suspicion or hunch, but considerably less than proof of wrongdoing by a preponderance of the evidence. So okay, so what does this mean? It means that you don't have to say reasonable suspicion is not the same thing as saying, I think more likely than not this person has a weapon, but it can't just be a hunch. And so in the courts, I would say have explicitly avoided these sorts of statistical characterizations that we're talking about today. But I think it's reasonable here to think in terms of these statistical numbers, at least to get a back of the envelope ballpark estimate of the number of potential Fourth Amendment violations that we're talking about. Okay, so the other thing that we did here, so this, it says like maybe, is 1% the inchoate and unparticularized? I'm not quite sure. And so one way we tried to ground this in the data is we looked at the named plaintiffs in this case. So again, if you remember what I said before, is that the way these cases are decided is that you see particular individuals, particular cases, and then you evaluate on the facts in those in particular cases. And so we went through all these dozen or so named plaintiffs in the case, and I'm going to give you one example here. Here we have an individual, Devin Almanor, who's characterized in the opinion as a thin 5'10", 13-year-old black male, stopped at 10 p.m. in Harlem for quote unquote fitting description of behaving furtively. The judge in the case, Judge Shendlin, ruled that his stop was unreasonable by kind of traditional constitutional standards. We took that information available in the case, we plugged that into our statistical model, and what did we find? We found that there was about a 3% chance in his particular case of finding a weapon based on the available information. 3% is higher than 1%. If we actually use 3% as our threshold for what we call reasonable suspicion, in fact, 80% of stops, almost all of the stops that were conducted, fall below this standard. So again, it's not clear exactly where we're going to draw the line of reasonable suspicion, but this type of analysis suggests that a lot of stops, perhaps even a majority of stops, were violating this this constitutional standard. Okay, so doing this work now for almost a decade, I've definitely, and you might have the same feeling, is like, in some sense you're like, well, what am I telling you that's new? It's like we now understand, we hear all these news reports, we have a lot of anecdotal evidence, and to an extent even a lot of statistical evidence that have come out over the last few years, that there is, in many parts of the criminal justice system, there's deeply embedded systemic discrimination in various forms. Many of the places we look, we find it. And so what exactly is the role of data science in reform? And this is a question that I personally struggled with, quite a bit. And I'm saying, are we really just kind of spending all this time and this energy telling people what they already know, or is this really adding more to that conversation? And I think this is a tough question. I don't know the answer to it personally, but I do think for better or for worse, these types of methods I think have led to reform. Now there's this bigger question of, should we require these types of statistics to take the actions that maybe we should have done even in the absence of this type of statistical evidence? So I'm going to give you two quick examples of this. So a few years ago, we worked with the LA Times, writing a series of investigative journalism pieces investigating the LAPD. And it was interesting. So it was a close collaboration. And in fact, they used many of the methods that we had developed during our kind of time working on the Open Policing Project to analyze the LAPD specifically. And here, in their, one of their articles, they really kind of made this point that the statistical evidence is strongly suggestive that Black and Latino drivers are pulled over on the basis of less evidence than white drivers. Now, in another of these articles, actually came out a few days later after that article that I just showed you. In fact, the LA Police Department, they announced that they're going to dramatically cut back on pulling over random vehicles, and in part because of the statistics that had been shown, and also the attention that had been brought to this issue through community groups. So again, I don't think it's one or the other here. I don't think that the statistics were really the thing that fundamentally drove the change. I think it was this kind of large environment of the reporting of the action on the ground that was driving this. But I think, at least on the margin, this type of statistical evidence is hard for many policymakers to ignore, and it can be an impetus for reform in this sense. So another example is that we worked with the Nashville police department and mayor's office a few years ago. And at the time, in 2017, the per capita stop rate in Nashville was about 7 times the national average. So this is quite a lot. In 2017, the stop rate was about 1 stop for every 2 people in the city every year. And so this was a lot of stops. And when we looked at the data, what we found was that there were significant racial disparities. And overall, Black drivers were stopped about, per capita, were stopped about 50%, about 45% more often than white drivers. And in fact, if you broke this down by stops for what are called moving violations, like speeding, something like this, versus non-moving violations, broken taillight, registration issues, tinted windows. In fact, for this latter category of non-moving violation stops, we found that that the stop rate for Black drivers was about 70% higher than for white drivers. So really, this huge disparate impact for this category of stops, where it's not where it's kind of, I would say, often associated with racial profiling. And so it's not entirely obvious why we're even making these stops. And in fact, it has these huge disparate impact. Okay, so when we discovered this, we kind of went back to the police department and we tried to understand, what is the theory of policing here? You know, why is it that the police were conducting all of these non-moving violation stops in particular? And we discovered that the theory of policing here was something akin to broken windows, where the idea is that we're going to stop a lot of people for these relatively minor violations, just to sort of, you know, show presence. And the theory is that if you were to do this, then that would lead to reductions in outcomes like burglary, which is ultimately what the police in this case cared about. And so that was like sort of the theory of policing. There's not a lot of kind of evidence in the academic literature for that theory of policing, but, you know, nevertheless, this was a theory of policing in Nashville at the time, and arguably even across the country. This is a theory of policing that people have adopted. Okay, so once we understood that was the theory of policing, we were directly able to test that hypothesis. And we went in and we looked at, you know, kind of looking at this random variation, and when there were a lot of stops for non-moving violations and when there weren't, we discovered that, in fact, there was strong evidence to suggest that stops for non-moving violations did not lead to short or long-term reductions in serious crime. And so given this theory of policing, we found that this tactic did not seem to lead to these outcomes that the police department was hoping they would lead to. And so we recommended that Nashville dramatically cut back on these stops, in part because it would significantly reduce racial disparities, it would reduce adverse contact with the police, and our prediction was that this would not increase serious crime. So to their credit, the Nashville police department did do this, and so in the next year they cut back stops by about 60%. Over the next couple years, they ended up actually cutting stops by about 75%. And again, I don't think this was from the statistics alone. I think this was the statistics coupled with action on the ground, this kind of long-standing community involvement in pushing the police for reform. But in that context, I think these statistics were helpful in kind of taking that last step. And in fact, even after these quite large reductions in stops, about a 75% reduction in stops over the next couple of years, there was no increase in burglary or these other types of crimes that the department was worried about. And so in a sense, again, kind of highlights this idea of the way that statistics can be helpful in this type of in driving these types of reform. Now, you could still come back and be, well, it's like, why would I believe that any of these policies were going to be effective? My prior should have been, I should have, even in the absence of data, I should have known that these stops would have dramatic racial disparities, and that in fact it's unlikely to achieve these outcomes that a lot of people thought they were going to achieve. And I think that is not an unreasonable position. In fact, that was probably my view doing a lot of this work. I was like, in some sense, the data are corroborating what we already believe. And so this kind of sets up this tension of what exactly is the role of data science. In many cases, we are corroborating what many of us believe already. But at the same time, I think having that type of empirical evidence is hard to it is hard to ignore for people who are making these types of decisions. And in some cases, I have to say, I have actually been surprised by some of the results where we look and we don't actually see the type of discrimination that we might be expecting, or even the magnitude is quite different than what we're expecting. Okay, so now I want to switch gears a bit and talk about, not the ways that these types of analyses can be used to drive reform, but where direct algorithmic interventions themselves can be used to drive reform. So a little bit of a different take, still using these ideas from data science and computer science, but a different take on ways that we can drive reform. Okay, so every day in the United States, American jails hold about 500,000 people who have not been convicted of a crime. So I want you to kind of pause and think about this for a minute. This is an enormous statistic, and often when we kind of hear these large numbers, we just sort of washes over us, and we're thinking, okay, yeah, 500,000 people. But now we even think about that just for 1 minute. So 500,000 people every day, 500,000 people in American jails who have not been convicted of a crime. So what are they doing in jail? They're often waiting for trial, or they're waiting for the case to proceed. And in many cases, they're there because they can't afford bail. And so again, there's a presumption of innocence, there's a constitutional presumption of innocence, but yet they are detained in jail and often because they can't pay these what many people would think of as small bail amounts, but in practice are quite substantial bail amounts for large segments of the population. And so why are people incarcerated? Well, they're often incarcerated because there's this concern that they won't show up to court if they are released on their own recognizance without being detained. But of course, incarceration comes with these quite considerable social costs, job loss, inadequate support for dependents, strains on family relationships, social stigma. So these huge costs of incarceration, and coupled with this, when somebody sorry. So this is kind of the context of what's going on. And so now what are we doing here? We're working with the Santa Clara County Public Defender Office to develop alternatives to pretrial incarceration to prevent this type of these, to alleviate at least these types of huge social costs that are associated with this practice. And so what are the interventions that we're doing? They're very simple. The first is what are called personalized text message reminders. I'm going to talk about this more in detail. And the second is that we're offering free door-to-door rideshare service for people with upcoming court dates to help them get to court. So the idea here is if we can reduce the likelihood that someone will fail to miss their court date, then we can reduce this type of pretrial incarceration. And there are kind of two theories of change here. One is if we kind of overall lower the risk of this happening, then judges are less inclined to rely on pretrial incarceration to achieve these outcomes. And the second is even more direct, that if somebody is released, again, many of these people are released pending court proceedings. But if you happen at that stage to miss your court date for any reason, and often these are kind of reasons like you couldn't secure childcare, or in one case we talked to someone and they said they had to walk hours, literally 3 hours to court. And so back and forth, you can imagine that's an extremely burdensome thing to do, and so that's why they couldn't make it to court. And so if you miss court for any reason, then often the judge will issue a bench warrant. If you're picked up for a traffic stop or anything else like this, then you're often immediately incarcerated. And so these are the type of outcomes that we're trying to eliminate by using these types of these simple interventions like personalized text message reminders and transportation benefits to help people get to court. Now, of course, I want to emphasize here that in some sense, the right policy solution is simply not to jail people for these minor offenses. So, in my mind, this is really akin to missing a doctor's appointment. A lot of people, like I alluded to, are missing court not because they're trying to flee the jurisdiction, but because it's hard to kind of juggle your calendar. Often it's hard to get time off of work. All of these things that suggest that we should take a sort of more humane approach to these types of problems. But that's harder. It's harder. There's been some kind of movement in some jurisdictions on this, but I would say it's a harder thing to do. And so given the current policy environment, we have been working for these smaller changes on the edges of developing these personalized reminders and transportation interventions to help people get to court. Okay, so now how are we doing this? Well, we're using what's called this idea of reinforcement learning in computer science to efficiently personalize messages and allocate these limited transportation funds. So now let me just kind of briefly tell you how this works. So here we can imagine that we have these here's kind of a generic message. Hi, Jen, a reminder that you have an upcoming court date, court appointment next week. This is kind of one version of the message. Another is, hi, John, a reminder that you have an upcoming court appointment next week. Here are some resources to help you get to court. And another is here, the exact same message, a reminder that you have an upcoming court appointment next week. If you miss court, you may be arrested and booked into jail. So kind of three different variations of this message. And you can imagine that we actually have dozens or even hundreds of these variations of these messages. Now, the question that we want to answer is what option is the most effective? And what option is the most effective for people like John? And so this is the problem that this idea of reinforcement learning is trying to solve. It's saying we have all of these things that we possibly could do. How do we know which one is the best message to send to John when that upcoming court date is coming down? And we can personalize these messages in this way based on all this information that we know about John. For example, maybe, what is that alleged offense that John has to go to court for? What is John's kind of past experience with the criminal legal system? Has he been to court before? Does he know kind of how this works? Does he know what the consequences are? And so you can imagine, based on all this information, we can send these different types of messages to John to encourage that that appearance at court and ideally alleviate some of these downstream consequences. So just for context here, the Santa Clara County Public Defender Office is a quite large county. It includes San Jose in California. They handle about 25,000 cases a year. In the current appearance rates are about 50%. And so if you were to increase this even 10 percentage points to 60%, that would already mean thousands of fewer missed court appointments and accompanying arrests for missing court each year. So even these small, what I call algorithmic nudges, can have quite significant impacts on people's lives. And these messages are effectively free. We're sending them out right now, and they cost a fraction of a penny for sending out every message. They're effectively free, and it's an intervention that we can scale all across the country. Okay, so the second intervention that we're experimenting with in Santa Clara is transportation assistance. And so here the problem is we have limited budget to purchase rideshare trips for people with upcoming court dates. And so the question, and this is quite difficult, is who should we give those rides to? And we're preparing now to give out these rides this spring. And so one kind of natural approach to use here is to allocate the rides in a way that maximizes the number of people who make it to court. And so how do you do this? Well, you can estimate the benefit for each person for that ride. So you might say, well, this person is actually quite difficult for them to make it to court by alternative means. And so they would really benefit from the ride compared to somebody else. For example, maybe they live far from public transportation. And so we really, if we give them the ride, that's really going to make it likely for them to make it to court. And if we don't, then that's going to be hard for them to make it to court. And now we kind of rank. We know how much it costs to provide each person a ride. And so we just rank by this kind of benefit per dollar, and we give our limited budget to the people who are at the top of the list. So that's kind of a natural approach to allocating these rides. Now, what happens if we're to do this? Well, here's Boston, and Boston is like many cities in the United States where it's highly segregated. So this is a dot map that shows the residential population of Boston that's color coded by race group, and here the star shows the main courthouse. And what we see here is quite a lot of racial kind of homogeneity. And in fact, if we were to provide rides to people that were kind of cheapest, who are we going to give the rides to? We're going to give the rides to the people who are closest to the courthouse. And in Boston, these are people who are disproportionately white. And so in particular, we'd be excluding much of the Black community in Boston and much of the Hispanic and Asian community in Boston because they tend to live further from the courthouse. And so per dollar, it is more effective in this kind of narrow sense of getting the most people to court is to offer the rides to these people who live closer, who also happen to be white in this particular case. And so this kind of introduces this real tension when designing these types of algorithms. And so here, you might say, well, what does it mean to equitably allocate rides? One thing I might do is require that an equal proportion of people in each group receive these rides. That's not so I might say something like 10% of people in each race group should get these rides, kind of regardless of where they live. But now if I do that, what potentially is going to happen? So here's some hypothetical numbers to drive home the point. So let's say I just sort of maximized appearances without regard to any of these types of parity constraints. I might be able to get 1,000 extra people to court. But in that scenario, it might be the case that 30% of people in one group, so these white individuals in this Boston example that I talked about, end up getting rides versus 10% in another. But if I were to do equal allocation, I might be able to say now that 20% of people in each group will get these rides. But because I have forced myself to have this equal percentage of people who get the ride from each group. And because one of these groups is more expensive, in fact, that eats into my overall budget. And so now I can send out fewer rides overall, which means fewer extra people get to court. And so this is this kind of inherent trade-off that we have to grapple with, is if we do something that is that optimizes without considering all of these other kind of broader issues of equity and justice, then we can get the most people to court, but we have these disparities. And if we take these disparities into account, all of a sudden we have fewer people who are getting to court, and also in that case, potentially more people who are being arrested for missing court. And so there are no easy answers here. They're just tough questions that we have to grapple with when we're designing these types of algorithmic interventions. Now, the last thing I want to talk about, just in the last couple minutes, is that we've developed and we started deploying what I call this Raceblind charging platform. And so here the idea is that we're using what's called natural language processing, a tool from computer science, to automatically mask race-related information from police narratives. So why does that matter? So when district attorneys are reviewing cases and deciding whom to charge, they read these, in many jurisdictions, they read these police narratives. And so there's a worry that these decisions on who should ultimately be charged is tinged with either implicit or even explicit bias. And so our idea here is that we're blinding the narratives of race-related information to ensure more equitable downstream decisions. So here's an example. Here's a toy example. So we might have some unredacted narrative, like this is kind of the original narrative. And what we do is we automatically transform this to a narrative that looks like this, where now instead of an individual's name, because his name often reveals one's race, we just encode that as this kind of generic token. Race identifiers like black male here is replaced with a race, but we have to be careful here. Here the identifier is black jacket. Here we leave it, so we have to be able to disambiguate between these two types of uses. Neighborhoods often can tell you, because of the segregation that we just talked about, can tell you something about one's race, hair color, even the officer who's involved, because in many cases, many jurisdictions, the officer is assigned to specific locations. If you know who the officer is, district attorneys can predict where these stops were made, and then knowing where the stop was made can reveal information about one's race. And so kind of looking at all these factors, we end up with this redacted narrative that looks like this. And so again, this tool now, this race-blind charging tool, is now being used in several jurisdictions to inform these types of decisions. Now, one thing that I want to point out here is that at best, what does this type of tool do? It can eliminate or at least mitigate the impact that race is directly impacting a DA's decisions. The same way that when we were looking at this veil of darkness at the very beginning, that if we were to cover someone's race up, to the extent that that type of policy is affecting the people who are being stopped, the police officers' decisions on who to stop, we can reduce that phenomenon. But what this intervention can't do is it can't make us race neutral in this broader sense of if policies have a disparate impact on communities of color that are sort of race neutral in a literal sense, race blind charging isn't going to help us. So one example here is drug policies, where you might say we're going to just charge people for minor marijuana possession, regardless of race. That policy is race blind on its face. The race blind charging platform, isn't going to help us reduce disparate treatment in that case. But if it's the case that the individuals who are being arrested for marijuana possession are disproportionately coming from communities of color, we still have this disparate impact that we're not able to overcome using this type of race blind intervention. So this highlights that algorithms, when appropriately designed and used, can improve outcomes in some cases, but we still must carefully consider all of these broader policy choices that are setting up the environment in which these algorithms operate. Okay, so that was a lot of stuff that we've covered in the last 45 minutes or so. So thanks again to everyone for sticking around and paying attention to this talk. And just recapping what we've talked about. We talked about these 3 buckets of data integration and collection, data analysis, and tools and intervention, and specifically touched on this open policing project. I encourage you all to check that out. All that is available online if you're interested in the data. The ways in which we can assess bias in stops, both traffic stops and pedestrian stops, and then interventions that one can build using these ideas from computer science that we have actively started rolling out all across the country. So thanks again, everyone, for listening, and I'm looking forward to the Q&A.
Thank you very much for that, Sharad. So we'll now move into our Q&A portion. As a reminder, you may submit your questions using the Q&A function, and we will address as many as we can. So off the bat, I'm going to combine a few questions that we got from people from different states and different countries. And they were wondering, are there any resources for other states or non-US policing data projects? And how would someone obtain good statistics of these situations or support this type of work in their area?
Yeah, so it's a really good question. So one thing that actually makes the US quite challenging in this regard is that essentially everything is local. So it's not that, so every jurisdiction, every city is maintaining their statistics, their data locally, and they don't actually push this to the federal government to compile it. And so that's really why we were starting this this project to compile all this information in the United States. In other countries, there often, or at least in some cases, there are national databases that are already collected that have this information. So the UK, for example, there is a quite detailed public database on traffic stops and on pedestrian stops, and so there's been some investigation there. And so I don't know exactly in every country what is going on, but definitely the US in some sense is the most challenging in this regard because everything is done at the local level. So in the US, we looked at something like 100 cities in every state, but we couldn't get information from every one of them. Here, if you are interested in working and collecting more data, I encourage you to file public records requests. So on our Open Policing website, we give templates for filing these requests, and we have a video tutorial for helping people learn how to file these requests. And so it's very, very easy. You just kind of have to be prepared to do a back and forth and kind of send lots of emails, but you can do it. And I encourage you to do that. And when you get that data, we also have a tutorial for analyzing that data. And especially journalists, or if you're working in local community groups, often that information can directly lead to reform locally. So I love the local efforts to make this happen.
Great, thank you. We have another question in the chat asking, has the approach discussed today been applied to the field of corrections, and how can it be applied to the use of risk assessment tools in criminal justice?
Yeah, so it's a really, really good question. So it has been, so these types of approaches have been applied throughout the criminal legal system. And, roughly this is policing, the courts, and corrections. These are kind of the three big buckets. I've done a fair amount of work on the risk assessment side of things. And here there's this kind of one question is, how do you decide, like an algorithmic side, if you have a sense of who you would like to, in theory, or why you would like to detain people, you can build algorithms that have been shown to outperform unaided human judges. And there, the kind of main result is that you can often release many more people, in theory, using an algorithm and kind of maintaining overall public safety levels than if you were to not use an algorithm. But now the subtlety here is, in many cases, we probably should just be releasing many, many more people, even if we're not using an algorithm. And so there's been a broad movement especially in these pretrial risk assessments, to say that, in fact, only a relatively small number of people pose public safety risks. And so why do we even need to use an algorithm? Why do we even need to use a risk assessment? Let's just release people, the presumptively let's release people unless we know or we have compelling evidence to suggest that they pose a serious public safety risk. And so that's an approach that was recently taken in Illinois. A version of that is happening in New York and also in New Jersey. And so this is kind of the complexity of the situation.
Great, thank you for speaking to that. Another one, and again, we've seen this throughout the presentation, a couple of questions come in related to it. So I'm going to use one as an example here, which is, have you considered factors such as the crime rate of the area where the stops occurred, the racial makeup of those areas, as well as socioeconomic conditions? If data shows a breakdown of 50, 30, and 20 for stop and frisk among racial disparity, what is racial disparity of the area of enforcement, and does it align?
Yeah, so there are definitely, and this again, Nashville is maybe a good example of this, in that the stops that were happening there were happening in, quote unquote, high crime neighborhoods, which in Nashville especially were correlated with demographics. And the theory of policing there was that, the way to lower crime rates in those areas is to stop people kind of preemptively for these pretextual reasons in an effort to reduce crime. Now, given that theory of policing, we actually found close to zero effect of this strategy of stopping people for non-moving violations in achieving that. And so, yes, a lot of this policing is happening in, again, quote unquote, high crime neighborhoods, but we often don't see the impacts of this style of policing, leading to what one might hope for.
Great, thank you. And an interesting question that has to do with low income areas and what you're talking about with the reminders. Is there a way to account for low income people who have often inconsistent phone access with text reminders, and was that taken into account when preparing the algorithms?
Yeah, so this is a really, really good question, and it does turn out, perhaps unsurprising, a lot of people who are involved in the criminal legal system, they don't have sort of ready phone access. The phone numbers change often, and so we don't often have that kind of up-to-date information. Residential addresses are often not stable, and so it can be hard to contact people. This is definitely one of the things that leads to people missing court, is that it's just, they're not connected in the ways that sort of many of us take for granted. And so this kind of, in a sense, this is sort of the broad impetus for eliminating this type of incarceration, pretrial incarceration for missing a court date, because many people are missing court, not because they're trying to flee the jurisdiction, but because they have all of these other sort of things going on in their lives, which make it difficult to get to court. Now, that being said, given the system that we live in the world that we're kind of stuck with right now, is we have been exploring these, interventions that do require this type of technology. Now we did survey folks to see how often people had a steady phone number, how often people had access to a phone, and it was actually not as sort of low as I originally thought it was. So a lot of people now do have access to a phone. Even people who don't have necessarily steady housing often will have access to a phone. And one way that we are trying to help get around this is we're asking people for contacts if they would like, if they don't have regular access to a phone, or even if they do, if they want to give us a number of a family member or a friend who does, then we can text that person, and then that person can communicate to the person with the who has the upcoming court date. So we have tried to sort of deal with some of this on the edges, but it's certainly a hard question that doesn't have an easy answer.
Absolutely, thank you for that. Another question here we have. They are clear on how to look for bias in traffic stop data on an organizational level. They're less clear on how it looks when you're looking at an individual officer level, where, for example, an individual officer may only work on day shift or night shift, and where their patrol area may be disproportionately populated by one race or ethnic group. Any thoughts?
Yeah, so it's a really good question. And there are a couple of ways to think about this. So first of all, it is, I think it's a great observation that it's much harder to assess discrimination, disparate impact at the individual level. I mean, this is kind of the beauty of statistics of data science, is that more tends to be better. And, estimating these aggregate patterns is typically easier than estimating patterns at the individual level. But there are a couple of things you can still sort of, do here. So the first is, and again, I'll go back to our Nashville example. What we found, our Nashville example, is that what we found there is a relatively small proportion of officers were making a disproportionate number of non-movement violation stops. So it's something, I don't remember the exact numbers, but it's roughly something like 10% of officers were making 50% of the non-moving violation stops. So this isn't discrimination in sort of the sense that kind of many of us have in our mind, but it's certainly a form of disparate impact. If this is a policy that is not sort of broadly helping us achieve these policy goals of crime reduction, and it's having a disparate burden on communities of color, the fact that a relatively small number of officers are making many of these stops, that implies a direct thing that we could do. And so in some sense, that's good. We can just go to those officers and say, hey, this is like, not even necessarily saying you're doing something that was against policy, because the policy was do what you want to do. So it wasn't in some sense that they were doing anything wrong. It was just that they weren't instructed not to do this thing that they chose to do. And so in that sense, we can go in and we can directly change behavior in a way that helps us achieve the outcomes that we want to see. The other thing that's related to this is often in the work that I'm doing, I think that there's definitely there are instances in which there are individual officers who are engaged in deeply problematic behavior. At the same time, I think many of these problems are systemic and they rise above the level of any individual. And so here, these are the types of systemic reforms that this work is suggestive of, rises above, is this particular officer being discriminatory? What exactly is this person doing? But what are the policies that the organization can take to help us see the outcomes that we all want to see?
Yes, thank you very much. And we are at our time. So thank you to everyone who did ask questions. We tried to get to as many. See if we can fit this in with our 1 minute left. Has there been any work on applying similar analytical principles to see what aspects, if any, within the criminal justice system are doing better than might have been originally anticipated?
That's an interesting question. I mean, so in some sense, when you do this work, you're sort of coming in with, you're not coming in with a lot of, ideally, and I try to train myself to do this as well, is, not coming in saying, well, I'm trying to find discrimination. We're coming in, we have our beliefs about what's going on, but we're coming in saying, let's see what is happening in this situation. And so in that sense, all of this work is saying, it's like, well, maybe there's discrimination, maybe there's not. Our job as a researcher, as the analyst, is to try to identify where this is happening. And, often when I do look, I have found discrimination. When other people look, they found discrimination, but not always. And so in one jurisdiction that we're rolling out this blind charging platform we did this kind of preliminary study that tried to estimate the effect of rolling this out in their jurisdiction. And we were pleasantly surprised to see that, in fact, there was very little disparate treatment or evidence of disparate treatment in that jurisdiction. And so they had already taken these policies of implicit bias training and other sort of things that they were quite cognizant of to help reduce this type of direct impact of race on decisions. And for whatever reason, there did seem to be evidence of very little disparate treatment happening in that jurisdiction. So that was kind of pleasant to see. But it's not something that we typically see.
Wonderful. Thank you for sharing more on that. And thank you again, Professor Goel, for your presentation, and to all of you who joined us today.